Hey class, welcome to week 13. We are going to be talking about torts today. We're also going to touch on governmental sovereign immunity and the Federal Tort Claims Act. As we've been discussing, agencies are accountable to the public in three primary ways: judicial review, public access to government records and meetings, and also through liability. And it's that liability piece that we are going to focus on this week as well as next week. It's important for government employees because both the government and its personnel can be sued as part of a tort claim. If you think about government liability, it's really about the risk of performing services. So our governments at all levels, federal, state, local, they provide us, the public, with many, many services that range from obvious stuff like police and firefighters and education, to less obvious things like recreational services or planting and maintaining trees. So there's a lot of different government services. The ones particularly that are critical to the public health and welfare can involve considerable risk. And often that risk is based on discretionary decisions made by government personnel. So for example, let's say the local 7-Eleven gets robbed at gunpoint. The local police, who are executive branch personnel, they are going to respond. And if the robber jumps in the car and drives away, it's possible that the police will decide to engage in a high-speed chase. So, while the police are providing law enforcement services as expected, high-speed chases can be incredibly risky for pedestrians, cyclists, and other motorists. So if the police car hits a cyclist and sends him flying, that cyclist is going to suffer injuries. They'll definitely be physical injuries, but they might also be financial. If the cyclist's got to pay for the ambulance to take him to the hospital, medical care, might miss work and thus lose pay. So there are injuries here. And if that cyclist can't hold the government, the police department, liable, if they can't hold them responsible for making him whole after he was injured, then that cyclist would be forced to deal with the monetary consequences of government action on his own. In the old days, because the king was sovereign, a subject could not sue the king. And that concept of sovereign immunity has transferred to our current federalist system of government. The federal government and all of our state governments are sovereign entities. And historically, that means we can't sue them unless they consent to be sued. But it would be wildly unfair to make an individual member of the public responsible for physical and financial consequences of government action. And so governments have waived some of their sovereign immunity. They've agreed to be liable for certain torts. And that's just because it is more appropriate for the government to bear the costs of its own actions than for a private citizen injured through no fault of their own to bear those costs. Making the government pay for injuries that it causes is also a good tool for controlling agency discretion and preventing abuse of discretion. If you know that you're going to have to pay the consequences later, you'll be on the lookout for policy and operational paths that don't create that sort of liability. So tort liability can be very costly, but you might be asking, what's a tort? Well, it is a delicious dessert, but it is also the field of law that deals with civil wrongs that do not arise out of a contract. So, our law breaks down into criminal and civil law breaks down into contracts and torts, pretty much. The word tort comes from Middle English, which drew on Latin. It means injustice or wrong. So if you have committed a tort, you have wronged someone. And it is tort law itself that defines what constitutes an injury and the circumstances under which one person is liable for another person's injury. All right, so why as public administrators do you need to know about torts? Well, for one thing, learning about them makes it less likely that you will accidentally commit a tort. But also, tort claims have a huge financial impact on agencies and taxpayers. This is especially true in law enforcement agencies, which get sued in tort for false arrests or civil rights violations or use of excessive force. At the federal level, The U.S. Treasury spends hundreds of millions of dollars per year. I think the most recent was around $320 million. But so that's what the feds pay for tort claims. And the Department of Justice handles thousands of tort claims that are filed against the U.S. each year. And that's just the federal government. In New York City, in fiscal year 2019, the city government paid about $220 million in tort claim damages for personal injuries and property damage, and it paid another $70 million to settle civil rights violations. That $220 million, that is 36% of the total cost of tort claims against New York City. We have seen quite a few recent high-profile settlements related to the deaths of Black Americans at the hands of their local police. The largest settlement in this recent bunch was paid by the city of Louisville, Kentucky, to the family of Breonna Taylor, who was shot and killed by police in her apartment. The city paid $12 million to settle that tort claim brought by Ms. Taylor's family. Plus, they also agreed to implement police reforms. Other settlements, $5 million for the estate of Laquan McDonald. That's $1 million for each of the 5 bullets fired by Chicago police that killed him. $3 million for the estate of Philando Castile, plus an additional $300,000 for his girlfriend, who was in the car when he was fatally shot, and $1.5 million for Michael Brown, who was killed by the police in Ferguson, Missouri. So contract claims and tort claims, these are both civil actions. Many states have waived a portion of their sovereign immunity for tort claims, but they have waived all of their sovereign immunity for contract claims. So as an agency attorney, please check with the legal office before you sign anything, because you might be facing, or your agency might be facing, unlimited liability if it's a contract claim. In contract claims, it's the contract itself that defines the legal rights and responsibilities of the parties. So if one party breaches the contract, the other party can sue for that breach. And often these breaches relate to a failure to pay for some good or service received. In tort claims, it is tort law, both statutory and common law, that defines the victim's rights, and in tort cases, the victim sues the defendant for a breach of the duty of care. So we'll discuss that more in just a moment, but let's just run through a couple of examples of tort claims. They include injuries from accidents, copyright infringement, defamation of character, false imprisonment, product liability, toxic torts, think of things like Aaron Brockovich, and trespassing. And while many tort suits are between private parties, the government has been sued many, many times over for each tort that's listed here, except for probably product liability. Now, you almost certainly know a lot more about torts than you think, and that's because tort law tends to mirror criminal law. So in a criminal case, you got the prosecutor and the defendant. In a tort case, you have the plaintiff, who's the victim, and the defendant. In tort law, the defendant is also known as the tortfeasor, the person who committed the tort. Now, when I say you know a lot about torts already, I mean intentional torts, because those are the ones that really mirror criminal law. So for example, there are the twin torts of assault and battery. Assault is the threat, battery is the action. So if I say to somebody, hey, I'm going to punch you in your face if you don't get out of my way, that's an assault. Then if I actually punch them, that's battery. You can have one without the other, but they usually do go together. Other torts include false imprisonment. That can be an issue for law enforcement, correctional, and immigration agencies, among others. There's trespass to land, which is what we think of as traditional trespassing. You're on a property that doesn't belong to you, and you weren't invited there. There's trespass to chattels, which is what happens when somebody messes with your stuff but doesn't actually steal it. If somebody steals your stuff, that is the tort of conversion, which mirrors the crime of theft. There are also emotional torts, such as the intentional infliction of emotional distress, and there are defamatory torts like libel and slander. both defamation, but libel is written, slander is spoken. So torts can be negligent or intentional, and it really all depends on the defendant's state of mind at the time they committed the tort. In an intentional tort, the defendant, the tortfeasor, is acting with a specific intent to perform the wrongful act that led to the plaintiff's injury. If I punch somebody in the face, that's an intentional tort. Negligent torts occur when the defendant doesn't use a sufficient level of care, usually in performing some duty that is owed to the plaintiff. And as a result of that insufficient level of care, the plaintiff is injured. So the defendant probably didn't have any intent to harm the plaintiff, but because of the defendant's negligence, not paying enough attention or not taking proper care in doing something, the plaintiff gets hurt. Negligent torts are the most common form of torts. They do require that there is a duty of care, a breach of that duty, and a resulting injury. There are also some torts that do not require a state of mind, so they are neither intentional nor negligent. One of those no state of mind required torts is strict liability. The other is vicarious liability. We're going to take a look at strict liability first. In strict liability torts, the defendant is responsible for whatever goes wrong, even if the defendant did not intend for that wrong to occur. There are just some actions that we can take where we are strictly liable regardless of the circumstances. We don't have to have a guilty state of mind. We don't have to be negligent. In fact, we might be taking all possible precautions to mitigate the harm, but we are still liable. And there are three main categories of strict liability. There's product liability, abnormally dangerous acts, and harm caused by animals. Product liability, as the name implies, that is the liability associated with consumer goods and consumable goods. So cars, computers, medical devices, food, prescription drugs, etc. And there, it's the duty of the product manufacturer or the product vendor to produce and or supply a product that is not going to cause harm during normal use by the end user. If it turns out that the product is unsafe, the manufacturer or the vendor is liable for the damage caused, even though they did not intend that to happen. An abnormally dangerous act is anything that carries a substantial risk to oneself and to others, either physical well-being or property. So abnormally dangerous act, think, shooting off fireworks, running a nuclear power plant, blasting rock with dynamite, anything where there's a good chance that something's going to go wrong, and if it does, somebody's going to get hurt. To be considered abnormally dangerous for an act, the activity's got to be highly risky, with the potential to harm people or property, or it's got to be highly likely that the harm will result from the activity, or it's not possible to mitigate the risk even by using reasonable care. And an act that is abnormally dangerous in one situation might not be abnormally dangerous in another. It all depends on the variety of circumstances involved. Liability for animals is another form of strict liability. The person who owns or is otherwise in possession of the animal is liable if that animal causes injury to another person or another animal. So that can include pets. If your dog bites somebody for no reason, you're probably going to be liable for that person's injuries. It includes livestock. If your cow or your horse or your goat gets out of your property and creates a car accident, you might be liable. In addition to standard animals, there is what I would call the strictest of strict liability if you own or possess an abnormally dangerous animal. That includes tigers and bears. It also includes things like snakes and monkeys, as well as wild animals that you may have tamed. Private zoos, like the one formerly run by Joe Exotic, the Tiger King, these are bastions of strict liability just waiting to happen. It doesn't matter if the tiger is in a secure cage, within a secure area, within a barbed wire fence perimeter. If that tiger gets out and it goes on a rampage at the local grocery store, the owner of that tiger is liable for damages. Now, one thing I really enjoyed about the Tiger King miniseries was spotting all of the various potential tort claims. It was very much like a law school exam fact pattern. And in our classroom, I have linked to an article about all of those Tiger King tort claims or potential tort claims. It is worth taking just a quick read. The other tort that doesn't require the defendant to have any particular state of mind, or even require the defendant to be personally involved, is vicarious liability. This is also known as respondeat superior, should you ever need to know that for a trivia game. In vicarious liability, the defendant is responsible for activities that go wrong, even if it was somebody else who committed the action. This most frequently comes up in employer-employee situations where the employer is held liable for torts committed by employees. So in vicarious liability, the defendant's liable even if the defendant didn't take any action, and that's because the defendant is supposed to take appropriate action to control their employees. If you're a supervisor and you're supposed to watch Janet as she trains on a piece of heavy equipment, then you can be liable if you're not watching and Janet winds up injuring someone. Vicarious liability, it is a major source of tort liability for government agencies, so you should take care to properly train, supervise, and discipline employees, because that is the duty of care that you owe to the public as well as to your other employees. So intentional torts, they're pretty easy to figure out because they're so similar to crimes. Negligent torts can be a little bit more difficult to grasp, so let's run through some examples. There is a tort of negligent infliction of emotional distress. The defendant doesn't mean to inflict that distress, but the defendant's negligence led to the plaintiff being in emotional distress. This can be really hard to prove, barring cases where the defendant negligently killed someone. But my favorite case involving negligent infliction of emotional distress is the contadina tomato paste case. It was a long time ago, but in that case, a husband and wife, for many years, they would cook a homemade Italian dinner on Friday evening, and then after dinner, they would engage in some intimate couple activity. And they always used contadina tomato paste to make their special dinner. And then one day, the wife opened up a can of contadina tomato paste and found a human thumb stuffed in there, along with the tomatoes. Kind of gross, definitely unexpected, and because of that, she was no longer interested in being intimate with her spouse. She was so shaken up by finding the thumb that she just wasn't herself for a long time. So the husband sued contadina for loss of consortium, which is the inability to have intimate relations with your spouse, and the wife sued contadina for negligent infliction of emotional distress because they negligently allowed a human thumb to get into their can of tomato paste. Now, the contadina couple, they did not win their cases, but it was a good try. Other negligent torts are car accidents and slip and fall accidents. Important to agencies. Well, car accidents and slip and fall accidents can be important to agencies because they got motor pools and they've got sidewalks that they need to de-ice in the winter. But also important to agencies are the torts that involve negligent hiring, negligent retention, negligent supervision, negligent assignment, and failure to train personnel. So if you are a supervisor and you're responsible for other employees, you've got a duty to hire the right employees, train them appropriately, and supervise them appropriately. And if you fail to do any of those things, then you're guilty of negligence, and the employer, if your employee injures someone, the employer is guilty of a tort. Also key for some agencies is the failure to protect the public, which is a tort if you work for a government agency that specifically provides public services for public health and welfare. So negligent torts, and these are primarily the types of torts that government agencies face. They have these three elements. So the first element is the duty of care. The defendant owes some duty of care to the plaintiff. And we determine this by the reasonable person standard. We ask, or the court asks, what would a reasonable person do under the same circumstances?
And a reasonable person is somebody who will take a precaution where the cost of taking that precaution is low and the likelihood of injury if you don't take that precaution is high. So the courts consider the burden of taking the precautions, the likelihood of harm, and the seriousness of harm that might be caused. So let's think outside of the government. Let's just think about neighborhoods. Neighborhoods with children. Somebody has an in-ground pool in their backyard, and the person who owns the pool knows that there are a bunch of little kids next door who try to sneak into the pool. So a reasonable person in that situation would fence their backyard so that people, particularly young children, do not have unfettered, easy access to the pool. And a reasonable person would think about, well, the cost of a fence, yeah, it actually costs quite a bit to build a fence. I just built one and it was about $5,000. But think about the likelihood of harm. If you've got a bunch of little kids who are trying to get into your pool, they're going to certainly try, and if you don't put up a fence, they're going to have an easy time of it. Seriousness of the harm that might be caused, well, somebody could drown and a little kid could die. And so you sort of do this cost-benefit analysis, and suddenly $5,000 to build a fence around a pool doesn't seem like that much of a burden when you're thinking about a child's life. So a reasonable person would fence their pool. That's the duty of care that is owed. You have a pool, you have a duty of care to people around you to keep it in a safe manner, so you fence it. The second element is a breach of the duty. You don't fence your pool in even though you know you've breached your duty. And then that third element is that there is an actual injury to the plaintiff that is related to your breach of duty. So if you happen to be lucky and you don't fence your pool in and the kids go play in it and nobody is hurt, well, you have not committed a tort because there's no injury. But you are a tort waiting to happen. So the duty of care is the legal obligation that all of us act reasonably when we are doing anything that might foreseeably cause harm to other people. So we just have to act like normal, common sense people. The foreseeability of the harm is a factor here. And this can be something like, in the pool example, well, it's easy to foresee that kids are going to jump into the pool. But foreseeability of harm can also go far into the future. So if you build an apartment building and you as the general contractor cut a bunch of corners, it is foreseeable that a couple decades in the future somebody is going to be harmed because of those corners that you cut when you were building the apartment building. So somebody might not be harmed right away, but you cut enough corners and eventually something's going to happen. So foreseeability can be long-term. Oftentimes it is shorter term. There is a multi-factor test for this duty of care, but it varies by jurisdiction. And it almost always contains foreseeability, but then it also is, what's the connection between the defendant's conduct and the injury? Is there any moral blame attached to the defendant's conduct? It's kind of interesting because we rarely talk about the moral aspects of this, but it does come into play in tort law. Do we want a policy of preventing future harm? This is why a lot of times HOAs have various policies. Consequences to the community of finding that there is a duty of care. Is there insurance available to cover that risk? Does homeowners insurance cover this? Has the defendant tried to do a good job? This kind of goes back to the moral blame. And then are there alternatives that could be in place? So all of this courts will determine depending on the jurisdiction and what the local legislature has set forth. They might consider these aspects when they're looking for whether or not a duty of care exists. Also, this duty of care is affected in sort of the corporate or commercial world and the government world by industry or professional standards, including manufacturing standards and standards of medical care. So the defendant, a reasonable person, would live up to the standards imposed by their particular profession or industry. Okay, so types of duties owed, and this might make the duty of care thing make a little bit more sense to you. You owe a duty to somebody that you have invited onto your property, and the duty that you owe them is a duty not to harm them. So, at my old house in Colorado, I had an unfinished basement that was primarily for storage. It used to be a root cellar, and it had some really tricky stairs leading down to it. And so, if any of my friends came over, if they needed to go downstairs, I would always point out that these stairs were pretty tricky and they needed to be careful because I had a duty not to harm them. If I had allowed a friend to come over, get drunk, and then I asked them to carry something heavy down those stairs, I'm breaching my duty because I know that they're going to trip and fall and take a fall down the stairs because those stairs were horribly unsafe. They were legally up to code because I was grandfathered in, but still, I knew they were unsafe, and so I had a duty to warn my guests about them. You also owe a duty to known trespassers and sometimes to unknown trespassers. So, again, if you are in a neighborhood and you know that kids cut through your yard all the time to go to school, well, they're, not really allowed to cut through your yard. They're trespassing. But because you know that they do this, you have a duty to make sure that, there aren't like open bear traps in your yard or something that could get a kid. If you have a lot of land, you also have the duty to, a potential duty to unknown trespassers, which is why oftentimes you will see no hunting private property signs posted. Those are landowners who are trying to perform their duty to unknown trespassers. They're saying, look, this is private property, don't come on here. Businesses owe a duty to consumers that their products are not going to cause harm. There's also a fiduciary duty that you owe to your business partners or to shareholders or to customers, and this also does apply to the government. Managers need to be attentive and prudent in performing decision-making and supervisory functions. And there is what we call a business judgment rule, and it assumes that directors or officers carry out their functions in good faith, after sufficient investigation and for acceptable reasons. But that's about directors and officers at for-profit companies. But government managers do also owe this duty to be attentive and prudent in performing their duties. Professional rescuers owe a duty to rescue within the scope of their employment. So if you're a firefighter and you're on the clock, you do indeed have a duty to go run into a burning building and save somebody. If you are not a professional rescuer, you are just a regular person, you do not have a general duty to rescue anybody. So if you happen to be up on a bridge and you see that somebody's fallen into the river and they're getting swept away and you don't, you're not a professional firefighter or a park ranger, you have no duty to go rescue that person. If you decide to rescue that person, you have to use reasonable care. So you can't be totally stupid in your attempt to rescue. Although there is no general duty to rescue other people, you do have a duty to other people if you have created a hazardous situation that injures them. So if you create a hazard, you do have to help people that fall into your hazard. Parents and schools have a duty to rescue children. Spouses have a duty to rescue each other. So if you're married and your house is burning down and your spouse leaves without you, you can go ahead and sue your spouse in court for a tort. Of course, you probably have bigger issues than a tort lawsuit, but spouses have a duty to rescue each other. Employers have a duty to rescue their employees. Common carriers have a duty to rescue their passengers. Common carriers are like United Airlines and Amtrak and Greyhound. So buses, planes, trains, they have a duty to rescue passengers. Okay, so we talked about the duty owed and the breach of that duty, and then that breach has to cause the plaintiff's injury. So it has to be an actual injury suffered by the plaintiff, but that is construed fairly broadly. It can be a physical injury, financial injury, property damage, or something intangible like invasion of privacy, emotional distress, defamation. That injury does have to be caused by the defendant, and it can be directly. You would not have been hurt had the defendant not punched you. Or it can be proximate cause, where your harm was a foreseeable result of the defendant's act. So that one can be a little bit trickier to prove. However, if what the defendant did wound up injuring you, even if it wasn't direct, it's an indirect injury, you can still recover for it. So when we talk about torts and we talk about government liability, I'm not sure that I've ever fully defined liability because I'm so used to using it as an attorney. Liability simply means that a party is legally responsible for some action. And usually it means they're financially responsible for some action. So you do something, it hurts somebody else, you are liable, you will pay monetary damages. Because that is usually how liability is resolved. The court will award monetary damages. The court can also issue an injunction which requires that the defendant do something, or the court can prohibit the defendant from doing something.
So a quick recap of common types of liability for public employees. Where the government is concerned, it's just called public liability. It's just a standard tort liability, but in this case, the defendant happens to be a public entity. There is vicarious liability, which, as we discussed, that's a biggie for government agencies, because the government, as an employer, is responsible for the actions of employees that are performed in the course of employment. So if I am driving from one part of campus to another for a meeting, and I hit a student who suddenly lunges out to the street in front of me, then my employer is on the hook for damages, assuming that I wasn't driving recklessly and assuming I didn't intend to hit the student. With vicarious liability, there's a distinction between a frolic and a detour. If an employee makes a minor detour from their job duties and hurts somebody or damages property, the employer is still liable. If I decide I'm going to swing by McDonald's on my way back from a meeting to pick up lunch, and I hit a student as I'm pulling out of the McDonald's parking lot, my employer remains liable. I just took a little bit of a detour. But if I'm off on a frolic, I'm acting totally apart from my job duties, and my employer is not liable. So, for instance, if instead of swinging into Mickey D's for lunch, I decide to drive to the beach and I hit somebody on my way there, I'm liable and my employer is not. Clearly, I am off on a frolic because driving to the beach has absolutely nothing to do with my job duties, unfortunately. There's another type of vicarious liability that applies to the government, and it is what we call under the color of law liability, also known as Section 1983 liability from the statute that created it. And this is liability for the acts of government employees where their actions caused harm and their actions are somehow related to their official authority. The action does not have to be within the actual scope of their employment. It just has to be somehow related to their employment. And we are going to talk a lot more about Section 1983 liability next week. So if you sue somebody for a tort, including the government, and you win, you will most likely just get monetary damages. And these are broken down into two categories, compensatory and punitive. Compensatory damages, they just compensate the plaintiff. They are intended to make the plaintiff whole after the injury. And that might include reimbursing the plaintiff for actual out-of-pocket expenses, as well as for foreseeable future out-of-pocket expenses, reimbursing the plaintiff for loss of income due to the injury, reimbursing for legal fees, and also reimbursing the plaintiff for actual pain and suffering. Punitive damages, on the other hand, they are intended to punish the defendant for wrongdoing. It's not about making the plaintiff whole after an injury, it is about making sure the defendant doesn't take that action again. And in the corporate world, punitive damages against one defendant usually impact similarly situated parties with that theory of general deterrence. So if one company gets dinged with punitive damages, other companies, probably competitors, are going to take a look at their actions to make sure that they're not doing anything that would also lead to punitive damages.
There are also some defenses to negligent torts. One of those is contributory negligence. So if the plaintiff also acted negligently and the plaintiff's behavior contributed to the harm that they suffered, that's going to offset some of the damages that the defendant has to pay. Because yes, the defendant was negligent and harmed the plaintiff, but the plaintiff was also negligent and that contributed to their harm. Another defense is assumption of risk. So if the plaintiff knew the danger and voluntarily decided to accept that risk, the defendant might be able to block any type of award of damages. Assumption of risk is often contractual, so if you go ziplining, you're probably going to sign like a waiver that you're not going to sue them, that you understand that you're engaged in a dangerous activity. So if you assume the risk, you might not get anything whatsoever from the defendant.
So to recap tort law in plain English, you ask, has someone done something wrong? If yes, has someone been harmed because of that wrongdoing? And if yes, should that person who was harmed be compensated for the harm? If the answer to all of those is yes, then that person who was harmed, the plaintiff, has a good chance of winning a tort suit. Now let's turn to the ways that the government itself is liable in tort. You can sue the government as a whole, Gartner v. United States. You can sue a specific agency within the government, Gartner versus Environmental Protection Agency. Or you can sue a specific government employee, Gartner versus Andrew Wheeler. If you sue a government employee in their official capacity, it's just the same thing as suing the government itself. We've read some cases where one of the named parties is a cabinet secretary or a state governor. They're being sued in their official capacity. Their name is on the case because they hold that office at the time the suit started, but it probably has nothing to do with them personally. And in fact, if they leave their position, stop being the governor, that case keeps moving along with their name attached. If you get sued in your individual capacity, then you are the defendant, not the government. And a plaintiff might sue an individual employee if they think that that employee is at particular fault. We see this sometimes with law enforcement. A plaintiff might think a particular police officer is at fault, but not have any concerns about the police department as a whole. A plaintiff might sue an individual employee because they can't sue the government, or because the government requires the individual employee to be named. Now, generally speaking, if you work for the government and you're acting within the scope of your employment, then you're going to be protected from liability. Instead of you getting sued, the government would step in and it would indemnify you. Basically, it just steps into your shoes and it acts as the defendant, and you don't have to worry about getting your own lawyer or anything because you're going to be represented by the Department of Justice or State Attorney General or something similar.
Sovereign immunity is a legal doctrine that says the government's not liable for anything. An individual cannot sue the government unless the government consents to be sued. The government has to waive its sovereign immunity. And this goes back to old, English times when the king was a sovereign and you couldn't sue the king because that was simply unheard of. This is where the concept comes from. The federal government, because we realize that sovereign immunity creates an inherently unfair position for those of us who might have been injured by the government or its employees, the federal government has waived most of its immunity. It has consented to be sued by its citizens via the Federal Tort Claims Act. State governments also have waived immunity for many, many, many torts. And sometimes the federal government puts a little bit of pressure on the states to waive that immunity. But the feds and state governments have consented to be sued in court. The incident that gave rise to the Federal Tort Claims Act was an Empire State Building crash. A B-25 bomber in July of 1945 flew directly into the Empire State Building in New York. A lieutenant colonel, he was piloting this bomber from Boston to LaGuardia, and even though he knew that there was zero visibility because of really dense fog, he attempted to land. He was very disoriented, and instead of landing at LaGuardia Airport, he crashed into the Empire State Building. He hit it between the 78th and 80th floors. I've got a picture there for you. One engine from the bomber shot through the building and into the next block, and it actually started a fire in an apartment building, and it destroyed a penthouse. The other engine fell down an elevator shaft and started a fire in the Empire State Building. And that one, the engine that hit the elevator shaft, weakened another elevator, which plummeted 75 stories to the ground while first responders were trying to help the elevator operator. Random fact, the elevator operator, she survived that fall and holds the Guinness World Record for longest elevator fall survived. And also, more importantly for the rest of us, Congress passed the Federal Tort Claims Act to give Americans the right to sue the federal government. So, the Federal Tort Claims Act, it is the statute that waives much of the federal government's sovereign immunity to tort claims. And it gives federal courts jurisdiction over tort claims for damages to compensate plaintiffs for injury caused by negligent or wrongful acts or omissions by a government employee acting in the scope of their employment in situations where the U.S. government, if it were a private individual, would be liable under tort law. So, you'll see some asterisks here. One, Congress has not waived sovereign immunity for all wrongful acts. It does give the courts jurisdiction over wrongful acts, but you might not be able to collect damages. Secondly is this whole where the U.S. government, if a private person, would be liable under tort law. This means that the federal government has not waived its immunity for uniquely governmental conduct. So if you or I would be incapable of performing this particular conduct, such as going to war, the government is not liable under tort law, so you cannot collect damages. However, if it's a regular old accident or something, the government is liable. There are these exceptions to the Federal Tort Claims Act. The government has not waived liability for executive functions, which is its internal administrative workings, and also for claims that arise in foreign nations. You cannot sue the government. It is still immune. The government has not waived immunity for intentional torts unless they are committed by law enforcement agencies. So if somebody from, well, let's say the postal office, goes postal and commits assault and battery, you can't sue the government for it. Because they've not waived their immunity when it comes to intentional torts. However, if an FBI agent or a police officer or some other law enforcement official falsely imprisons somebody or arrests them falsely or maliciously prosecutes or commits assault and battery, then the government is liable because they have waived that immunity. Other intentional torts like libel and slander and interference with contract, the government has not waived immunity, so it's not liable for those. And then acts that fall outside of scope of employment, the government's not liable for that. You can sue the person as an individual. And then discretionary functions. So if there's policy planning and judgment involved, if you're making judgment calls, the government is not liable for that because it wants its employees, it needs to make those policy planning and judgment calls. However, the government is liable for ministerial acts. So if you're just carrying out a specific function that you have to carry out and anybody else would carry it out in the same way because that's what your government job says to do, and you injure somebody, the government is liable. To determine whether or not there's a discretionary function, courts apply this two-part test. Is there an element of judgment? Is somebody making a choice? If so, it's a discretionary function. However, if a statute or a regulation or a policy specifically says you have to do A, B, and C in this situation, then there's no judgment, and it's ministerial. The courts also look to whether Congress wanted to shield particular government employees from liability. So when people in the government have to make socioeconomic and political policies, obviously they're not going to make everybody happy, and they are shielded from liability for that. Another exception to the Federal Tort Claims Act is called the Vicarious Doctrine, and that comes from a case, Ferris versus United States, which was actually two cases that were combined. One, a soldier died in a barracks fire, and the military knew that those barracks had a defective heating unit that would probably catch the barracks on fire. In the other case, a soldier had abdominal surgery, and then 8 months later he was having like really severe pains, and another surgeon removed a 30-inch by 18-inch towel marked Medical Department, U.S. Army from his abdominal cavity. Naturally, the soldier sued, but because of the Ferris Doctrine, the courts found that the federal government has not waived sovereign immunity for injuries to military personnel while on active duty, even if those injuries result from negligence of their fellow members of the armed forces. This also bars family members of military personnel from filing wrongful death suits. Back when we invaded Iraq and a lot of people felt that that was not appropriate, there was this talk of, well, families should be able to file wrongful death suits because this was a bad idea to go to war in Iraq. Doesn't matter, they can't do it because of the Ferris Doctrine, and also they wouldn't be able to do it because of this concept of the United States as an individual person would have to be able to commit a tort, and individuals can't commit war. So hopefully I haven't totally confused you on this. Generally speaking, the federal government has waived its immunity, and we can sue it in tort just like a regular person, but in certain circumstances we cannot, and one of these is for military personnel engaged in active duty. This was actually, a picture of the towel that was left in this poor guy. So, with limited exceptions, the government has said, yes, you can sue the government in tort. We will be liable for any injuries that we cause to you. Because generally, the government owes a duty to the public as a whole, the public duty doctrine. However, the government does not owe individual members of the public any duties, unless there's a special relationship. So, the CDC has a duty to all of us as members of the general public to contain something like a SARS outbreak. But if I come down with SARS, which given how I've been going this semester wouldn't necessarily be a strange thing, I can't sue the CDC for breaching any duty because the CDC does not owe me, Jen Gardner, any duty. It just owes us, the general public, a duty. However, when there's a special relationship, it can create a duty to a particular individual. And in your textbook, there's a case, Marin v. United States, where the INS released a violent prisoner to work undercover. They wanted help from this prisoner. The INS knew that the prisoner was obsessed with the victim, but never bothered to tell her, hey, we've released him from custody and he's working undercover. In addition, the INS lost track of him. They didn't supervise the prisoner adequately, and he escaped and he killed the victim. And the government was liable in this case because it created this relationship between it and the victim. The government was responsible for releasing the prisoner, the government failed to supervise the prisoner, and the government knew that that prisoner posed a danger to one specific individual, and thus the government had a duty to that one specific individual. Public duty to all of us becomes this individual duty to a specific one of us if the government created the risk that injured us, if it increased our risk of injury, if it aggravated an existing injury, if the government had custody or some form of control over the plaintiff, and or, because it's yes to any of these, if the government had a legal duty because of a specific contract or custom or policy or statute. So if the answer is yes to any of these questions, the government does owe a specific personal duty. And the government will pay damages for breach of duty. It is liable in tort claims as though it were a private individual, except that it won't pay prior interest. It won't pay punitive damages, which is actually a good thing for us as taxpayers, because we could not afford that. The government will not pay attorney fees in regular tort cases, but it does pay attorney fees in federal civil rights litigation, which we'll talk about next week. And most states have passed statutes that similarly limit their liability. So, for instance, in Maryland, where I practice law now and I work for the University of Maryland, we have the Maryland Tort Claims Act, and liability is limited to $200,000 per person per incident. So they're limited on what you can collect. So damages are a concern for the government, but because the government limits the amount that a plaintiff can collect based on a single incident, damages aren't actually the main concern usually for government agencies who are sued in a tort claim. Litigation itself takes an enormous toll on agencies. And this includes negative publicity and criticism of the agency and all of its managers, the potential for legislative hearings or investigation. You know, when you're working for the government, you really don't want Congress to convene some type of legislative hearing on what you're doing at your agency, nor do you want the Attorney General to launch an investigation. The pre-trial discovery process is incredibly burdensome. You've got to take depositions, which have to be done with all of the attorneys present, and everybody's under oath, and you have to pay for a stenographer. It's quite expensive to have a deposition. There are requests for documents, so you've got to go digging through all of your files and your hard drives and your shared drives and all of this for documents, which is extremely time-consuming. There are interrogatories, which are like depositions, but they're all written, but you're still under oath. Those take a long time to fill out. And then you've got to attend or have your attorneys attend all these pretrial motions and hearings. So just the pretrial process, before you even go to trial, is very, very taxing. It's very burdensome on the government agency, and if you as an individual happen to be dealing with one of these court cases, I mean, you can pretty much assume that you're not going to be able to get your regular job done at the same time. So yes, government agencies don't want to pay out damages, but they're much more concerned about litigation, all of that pretrial discovery, and then disciplinary action. Because if they're going to take disciplinary action against an employee, they've got to deal with the whole grievance process. And, you know, we've read about formal adjudications. It can be enormously expensive. And all that's going on at the same time that you're dealing with a lawsuit in civil court. So it's impossible for government agencies to completely avoid litigation. The government will always get sued because the government is an enormous organization that provides countless services for us. And so just playing the numbers, they're going to get it wrong sometimes. So it's not possible to completely avoid litigation. Chances are, if you work for an agency, your agency has been hauled into court, and it will be again. But agencies and the public administrators within them, you can take steps to reduce your liability. Quality control is the most important thing for reducing liability. And by reducing liability, I mean, in the event that you do get hauled into court, you're able to make a good case for yourself. You're able to say, look, we have proactively taken these steps to avoid injuring people. We have the correct standard operating procedures in place. We do the correct training. Your agency still might be found, guilty and assessed damages, but it's very likely that the court is going to reduce those damages because you have taken proactive quality control steps. If you don't, if you've got poor management, that leads to litigation. From your employees who are irritated with your poor management, to your customers, to people that you just accidentally injure because of this poor management. So you want to avoid that. You want good management, and that means quality control for both operations and for personnel. Management needs to be very effective and efficient in screening and hiring employees, training employees, evaluating and promoting employees, and most especially investigating employees if you think there's a problem. Now, I don't mean launch an investigation of every employee who seems like they're slacking off and spending too much time on Facebook. I'm saying if you know that there is a problem with one of your employees, particularly if you work for a law enforcement agency, you want to investigate and make sure that they are safe to be interacting with the citizens, and that they are not going to intentionally or accidentally hurt somebody. So you can reduce the risk of litigation. So you're either not going to be sued, or if you are, you can settle quickly by conducting post-incident evaluations. If something goes wrong, and there's a chance that it might, think about what happened. Like, really get in there and analyze it. Get the appropriate people involved. Get the agency's attorney there to give advice. So conduct these post-incident evaluations. Quickly and appropriately discipline employees if they're endangering people or property. And proactively get some expert advice if you're having problems with a particular operation. You've got a problem with a particular project or anything else. If there's an expert, a subject matter expert at hand that you can use, don't hesitate to bring them in. So that the first thing that you can do for reducing your risk of litigation is to conduct these post-incident evaluations. Figure out what went wrong and what you can do to correct it so that it doesn't go wrong again. Have your attorneys there, get the agency's legal staff in. Usually this will trigger attorney-client privilege so that these types of post-incident evaluations are not discoverable. You don't have to hand them over to the opposing party if you do get sued. If you have a problem and you know that it has the potential for causing injury, you're really increasing your risk of liability. So this is something that you would want to bring up to your supervisors in the agency, if you happen to see some issue within the scope of your employment and you think, this could be a problem for us, let's see if we can proactively address it. That will really reduce your liability and your risk of extensive litigation. The biggest challenge for most employers, and particularly for the government, is quickly and appropriately disciplining employees. If an employee should have been disciplined but was not, the agency is more vulnerable to lawsuits because you're on notice that you've got a problem employee and you're not doing anything about it. This sounds easy. It should be a no-brainer to discipline your employees. However, many, if not most agencies, they fail to use consistent disciplinary procedures. And they might do that because an employee is personally popular and the agency doesn't want to upset morale or rock the boat. The agency is engaged in union negotiations and doesn't want one more thing to deal with during that negotiation. And sometimes managers fear consequences of disciplining an employee. If that employee is intimidating, a manager might fear an actual physical confrontation, but more likely the manager is going to fear that that employee is then going to undermine operations with passive-aggressive stuff like calling in sick too much, getting other employees to call in sick, generally sort of stirring the pot on the line. And so that is often why managers don't appropriately discipline employees, which is unfortunate because it's not good for morale and it also does increase liability. Then there's this idea that you should seek expert advice. Potentially, if you're involved with an agency that engages in some dangerous operations, it's good to get an outside opinion. If you're going to start a project, you might want an expert to take a look and confirm that your plan of action is a good one. A lot of times agencies balk at this because expert fees are fairly high. I mean, you'll pay a good amount to get a decent expert in to sort of bless your project or your plan, but it's nothing close to what a lawsuit's going to cost. And you can keep that expert's report on the record to show that you are following best practices, and all of that will very much reduce your liability. It will reduce your chances of being sued, and then it will reduce the chance of having to pay out a large award if you are sued. So there are some ethical considerations involved here. All government agencies get hauled into court at some point, like I said. So the fact that an agency gets sued really shouldn't be construed as a major ding on the agency, because it's just going to happen at some point. What we want to make sure is that agencies realize that they are public service organizations. They should not confuse themselves with private for-profit businesses. Because for-profits will take any legal action necessary to reduce the costs of litigation, and this might include getting rid of a lot of their records or failing to investigate an employee. This can come back to haunt a for-profit, but for-profits are rightly concerned with the bottom line of money. Government agencies are not. Agencies have a higher duty to the public than simply making discovery challenging for potential plaintiffs that have been injured by government action. So public administrators have to act responsibly and conduct thorough investigations if there's an injury. Because if you fail to investigate, your agency's not going to have information that it needs to improve. You're not going to be able to hold the responsible party accountable. You're going to face increased liability in court, and you're going to lose the public trust. And that's really a big one. So there are ethical considerations in here. You shouldn't be solely focused on never going to court. You should be focused on being a public service organization.
All right, that is it for the lecture this week. This week, we do have discussion 8. It is going to be you pose the question. I'm actually just swapping our discussions. Next week, D9, that is going to be about torts. So that's the only thing due. For the policy analysis memo based on the survey, you're going to submit an outline of your memo instead of the full memo. I will post some new information about that in the classroom shortly. So thank you for listening. I hope you have a great week, and I'll see you on the discussion boards.